Good afternoon, everybody.
Good afternoon.
Thank you
There we
so
go.
much.
That's the enthusiasm.
People in the room, how's my volume? All right, good, thank you. I live in fear of microphones because I don't want to be loud, because as a child I was routinely shushed for being too loud, and that has stuck with me. So if I get too soft, you let me know and I'll scream a little bit. People online, if you're having difficulty with the audio at all, if there's something we can do on our end, like be louder, do let us know. We're monitoring the chat. All right. Welcome to the final session of this year's conference. Thank you all for being here. For those who are here in person, we know that you had to go through inclement weather to get here, so we're grateful for your presence, and we hope that you'll take away from this panel as much as we will take away from learning from each other. Just as a reminder that if you want to follow along with this session, catch up on photos from the rest of the conference, engage in the chat or anything else, you can do so through the Whova app, engaging with the HRC conference through the Whova app. I'm going to share with you a little bit about what our timing is going to look like today. So first, we will start with introductions from each of our panel members. We'll follow that with a discussion. I know I came here with my mind buzzing with a lot of questions I wanted to ask our panelists. So we'll have a little bit of a conversation there. Then we're going to commit time at the end for Q&A. That'll be to address any questions you all in the room have or anyone who's watching online. Again, we're monitoring the Q&A in the Whova app and also in the chat. And then afterwards, we'll do a really quick summary of takeaways. We will insist that you eat until there is no food left, and then we will send you home. All right. First, let's begin with introductions. Hello again, good afternoon. I'm Susana Davis. I work in the Office of Racial Equity, and it is a pleasure to be here with you today. I am joined by Mia. Would you just say hello?
Hello. Is there a button?
You have to say it with your heart, Mia.
Hello. Hello, everybody. I'm figuring this out.
We're working on our tech. In the meantime, I'm also joined by Big Hardman from the HRC.
I got it now.
All right. Hi, everyone.
And Julio Thompson from the Attorney General's office.
Hi, good morning, everybody. Good afternoon, I guess.
Your mic might be a problem.
Can you hear me okay now?
There we go.
Okay. Good afternoon.
I'll give my colleagues another opportunity to introduce themselves in a moment, but first allow me to tell you a little bit about who I am, and actually that's a lie, you don't need to know that. I will tell you what my office does. So again, I mentioned that I'm in the Office of Racial Equity, and so the main duties of our office, I do see a couple of legislators in the room. You'll note that the items on this list are things that were mainly assigned to us through legislation. So in our office, we are charged with identifying systemic racism in all three branches of state government. And then step two is we oversee the statewide collection of race data. We develop trainings, deliver trainings all over the place. Show of hands if you've ever seen me or someone from our office deliver a training. If you've had the pleasure of seeing Shalini give a training, you've been especially blessed because she's delightful. We also work with the Chief Performance Office to set performance targets and metrics for how other state agencies should be advancing their work to make sure it's being done equitably and inclusively. We have within our office the Division of Racial Justice Statistics, which is a team that is focused specifically on collecting, analyzing, and reporting on data related to the criminal legal system in Vermont. We also provide general advice and guidance, yes, to the governor and to the legislature and the judiciary, but also to peers across government. It's been many an evening when I just get a random call from someone. It says, hey, is this thing that we just did racist? Can we talk it through? And I pace barefoot on the floor with my SpongeBob pajamas and we just talk it through, and that's how government works. We also liaise between the cabinet, the Human Rights Commission, and the Workforce Equity and Diversity Council. That specifically is carved into our legal mandate, but really we liaise with and between a lot of entities, both in and out of state government. We receive complaints, we route them, we intervene when it's appropriate, and of course we report annually on our progress doing all of those things. Our team started out as a team of one, as is so true for this work. Many of you probably will relate. Now we are a group of 7/8, and we have, I like to group our work into buckets: education and outreach, policy and research, and then of course, criminal legal statistics. It's important to us that we be a mission-driven office. We are one of the few truly mission-driven offices in state government, and so we're guided by a vision and a set of values that really inform the way that we do our work. Our vision is threefold. We envision a Vermont where all state employees and contractors are treated equitably through their tenure with the state, and that includes being equitably represented in decision-making and leadership. We envision a Vermont in which all members of the public are receiving fair and appropriate treatment. And we envision a Vermont in which the state is creating and using comprehensive systems that make those first two things autopilot. We operate from a really large set of values, but the three that we keep coming back to the most are process equity in addition to outcomes equity. It's not just that we arrive at the right conclusion, we want to make sure that we got there in the right way. Also, structural solutions for structural problems, not individual solutions for structural problems. Asking people to find bespoke workarounds for systemic issues is not how you make genuine change for all. And last, transformative change over transactional change. That is to say, not making small tweaks to make individual problems or complainants go away, but really reforming the way that we do business so that we don't have to see similar recurrences of issues coming up again. You'll find examples of our work, including some of the educational opportunities that we offer. We do lots of trainings. We love to incorporate joy into the work. And so we do cultural celebrations. We hold an annual conference. We do data and research. We've issued a bunch of reports and also assist with working groups and other people who are doing their own reporting work. And of course, participation in policymaking, including our work around a statewide language access plan, ongoing testimony, legislative input, participating in big projects like the Economic Stimulus Equity Fund, which is where we were able to secure money for undocumented people in Vermont when Congress denied them CARES Act stimulus payments, and a lot more. So that's all that we do. No big deal. I want to invite BIG to introduce themselves and to share a little bit about the HRC.
Thank you so much. I know some of you might be kind of tired of hearing me talk now at this point in the conference, but this time I'm actually going to be honing in specifically on what the Human Rights Commission does on a day-to-day. So I started with the commission a little over 4 years ago in 2021. I started as a staff attorney investigator, and I was in that role for 2 years before I became executive director in 2023. We are an independent state agency, which means that we are not under the umbrella of any other agency or department, and we are all state employees funded primarily through state tax dollars. Our mission is to advance full civil and human rights in Vermont. We are seeking to protect people from discrimination, and we do that by investigating complaints, helping to resolve complaints whenever possible, filing lawsuits, and doing education and outreach like this event that you're all at right now. We have a statute that it authorizes us to exist and do our work. You can see the citation to that if you want to look it up. And we also operate with some administrative rules that govern some of the nitty-gritty of our complaint processing that can be found on our website. In the time that I've been working here, we have grown from 6 employees when I first started to 9 now. And that is solely to meet the needs of the Vermonters who are constantly calling our office, asking for complaint investigations, as well as training and outreach events. But this is an overview of our staff team. You have interacted with all of them this weekend while you've been here. We have our Director of Community Engagement, Kate Prabhu-Quam, who has been instrumental in organizing and putting on this event. Our Senior Counsel, Mitch Rotbert, who is our litigator. He is the one who takes our cases to court when we need to. This year, we just got in July an intake coordinator that is a full-time position that's able to process new intakes and inquiries to our office. That's John McKelvey over there. They didn't know I was going to say their names, but we also have 4 staff attorney investigators now. That's up from 3. You can find them scattered throughout this room. And our executive staff assistant, Vanessa Bonobo, who is now in the room, and I'm able to thank her for all her hard work on this conference as well. We have 5 commissioners who are appointed. Yay! We have 5 commissioners who are appointed by the governor. They serve 5-year terms. They meet once a month. It's really like a volunteer position. The idea being that they are typically non-lawyers, just like regular Vermonters, right, who represent a lot of the folks who have complaints in our cases demographically, and they really participate in hearing our cases once the investigation is complete. And they make determinations. Under our statute, they're authorized to make determinations of whether or not there's reasonable grounds to believe that discrimination occurred. Those are made in the public session, and they also approve our settlements of cases. These are our 3 buckets of discrimination cases that we are authorized to investigate. About half of our cases fall in the category of fair housing. These are not your standard landlord-tenant disputes. These are when people feel that they have experienced discrimination or harassment in housing, including denials of reasonable accommodation requests for people with disabilities. We also enforce our public accommodations anti-discrimination protections, and that includes any place that is open or serves the public. We are all free, we all have a right to be free of discrimination in those places. It includes like any kind of business, storefront, schools, any government office or entity, the police departments are places of public accommodation, corrections. It's an extremely broad statute, and I think a lot of folks don't realize that they have a protection against discrimination in these places. We also have a small category of employment cases that are just brought against the state of Vermont as the employer. And you will hear from Julio next about all the other employment cases that are handled by his office. So I just want to give you a quick overview of what our complaint process looks like. It starts with an intake, and those happen either often by email or by phone, that people are contacting us, telling us that they believe that they have experienced discrimination. Of course, with our small team, we are not able to investigate every complaint that comes through the door, so we do have a fairly extensive intake process, and we only can take a handful in comparison to the mountain that is coming in each year. But of the cases that we do accept for investigation, our investigators, our attorneys, they do extremely thorough document reviews and investigative interviews, and they produce investigative reports in any case that they are not able to assist the parties to a settlement. And I want you to keep in mind that our investigators are not representing any party to the case. We do not represent the complainants or the respondents. We are meant to be a neutral investigative agency. When an investigative report is complete, it is sent to the commissioners for a commission hearing, and the report contains a recommendation for the commissioners, which they conduct an informal hearing and hear from the parties and make their own final determination. If we find that there are reasonable grounds to believe that discrimination occurred, that opens up a 6-month time period in which our office is more heavily engaged in trying to see if we can settle the case. If we cannot, then we have the ability to enforce violations of the Act that we have jurisdiction over by filing in Superior Court, where the Human Rights Commission is the plaintiff. And we currently have about 15 cases in litigation right now. We also are trying to do prevention work throughout the state whenever possible, and that includes this laundry list of trainings that we have offered in the past year. This is our sort of capstone event, not featuring, you know, HRC staff as the experts, but really our community members. And I just need to take this little moment to put in a plug that you will receive a survey for all attendees at this event, and we would really, really love to hear your feedback on how you experienced this conference and what we can do better next year. We already know we need to do this again, and we need to do things like this more often, and we want to know how to make it best serve all Vermonters. So it's very important that you complete that survey if you can today. We'll probably bug you about it again later also. So that's an HRC in a nutshell. Thank you.
How do I advance the spacebar?
Probably. I was doing the over button.
The which button? This one. Let's see. All right, I'll just get started and we'll figure out the computer in a second.
Sorry.
Hi again, I'm Julio Thompson. I'm co-director of the Attorney General's Office Civil Rights Unit. I've been with the AG's office in Vermont for, I think this is my 21st year. Before that, I was a practicing attorney in the sleepy coastal town of Los Angeles, where I focused on employment discrimination, kind of specializing in glass ceiling cases, representing a lot of women executives in Los Angeles who hit the glass ceiling. I was also, beginning in 1991, I started getting involved in the then emerging field of police reform and civilian oversight. I was a deputy monitor, civilian monitor of the LA Sheriff's Department for over 10 years before I moved to Vermont. When I came here, I started working representing the state in employment and labor cases. So my first contact with the Human Rights Commission was when they were investigating one of my client agencies for alleged or suspected violation of the law. And part of our job there was to do our own investigation, and if we thought that our clients or our employees had done something wrong, then we would try to resolve that. And I think for all my cases, that's what happened exactly. I don't think we had a case go against us. Any case we thought, at least the cases I worked on where we thought something had gone wrong, we sought to remedy it. And the then Attorney General Bill Sorrell was behind getting relief to people who were harmed by things that the state had done. In 2009, I started in the Civil Rights Unit, and that's what I'm going to talk about a little bit now. The Civil Rights Unit is one of many different units in the AG's office. We have a criminal division that has equal authority to prosecute cases with the 14 state's attorneys for all offenses in Vermont. We also have an environmental law unit, which represents the state in national and state litigation and trying to keep our water and our air and our land clean. We have a public protection unit that helps thousands of Vermonters every year get relief from scams. Last week, I think, it was in the news that Walgreens had overcharged Vermont customers by about $500,000 by charging a higher price at the scan register than was actually the posted price. We've also represented the state of Vermont in the class action opiate litigation, where the Sackler family and other corporate giants were really spreading the opioid epidemic in a reckless and callous manner. And so that was part of the work that our public protection division did. The Civil Rights Unit, we have different functions. We do a lot of education, and that ranges from school kids to professionals like yourselves. I also teach one class at the police academy, the hate crimes class. And what we try to do there is just to give people an idea of what their rights and their obligations are. So we do trainings for employers as well as employees and labor representatives, because Vermont law changes pretty regularly, and we try to keep abreast of that. We also, like the Human Rights Commission, investigate claims of employment discrimination. Our processes are pretty similar, that we review a complaint that we receive and decide whether there's enough to proceed with an investigation. And then we issue a neutral report on what we find. We do not have commissioners that vote on findings. We are essentially a civil and criminal prosecutor's office. And so we just decide whether we think there's a violation, and we have the authority at any time to go to court if we can't resolve it. Fortunately, in nearly almost all of the cases where we find a violation, that finding usually drives the employer to the bargaining table, and usually there's a resolution. And that can range from a monetary settlement if a person doesn't want to work at the employer. It could also be providing reasonable accommodations for people who need that. Or it could be wide-scale changes of policies. One of the cases we had involved a serial sexual harasser that resulted in a $2.1 million settlement, 5-year consent decree with really far-reaching reforms for this employer that had deep-rooted institutional problems dealing with employees, especially younger employees. So the range of relief that we seek really depends upon the case. We also mediate cases, so before we dig into an investigation, if we think that there's room for the parties to reach an agreement, we'll offer free mediation. We have independent contracted mediators who will help the parties to see if there's room for them to repair that relationship, or if the employer's got problematic practices to remedy those. Our experience is about 3 out of 4 cases that go to mediation end up in a successful resolution. So it's a program that we're very proud of. We also, I would say, facilitate. So sometimes we're not the answer. People come to our office. We have this broad name, civil rights, but we're not really the people to help, either because the laws don't permit us to seek a remedy in court or otherwise, or just because maybe we're the wrong voices to be at the table. And so we work with a number of groups, including the NAACP. Me is a close friend and I'd say collaborator, where we do a lot of problem solving. If having the AG's office show up where there's a problem is gasoline on the fire, then we stay away and we find the right people, and sometimes that's the ACLU, sometimes that's Migrant Justice, sometimes it's the NAACP, or any other organization to try to solve the problem, because not every problem needs to go to court. We also, and I put this somewhat jokingly because I knew there would be legislators here, I put legislate, no, not really. We do have a special role in the legislature, which is to provide additional advice or analysis, and sometimes subject matter expertise to legislators who are considering different policies and bills. We can offer support in terms of empirical research, constitutional or other types of legislative analysis, as well as drafting assistance for the full-time lawyers who serve the legislature in the Office of Legislative Counsel. And I'm proud to have been doing that and working with some of the legislators that are here and have been at the conference. They've been doing excellent work, and I think it's been a real honor to work to help them reach the goals that they wanted to achieve. We also advocate, and I'll talk maybe in the Q&A, we'll talk about this a little bit. Sometimes we don't have authority to take someone into court, especially on issues of national import. And so there's a mechanism for filing comments under the federal rulemaking system, where we will write comments that will either support or oppose federal rulemaking on subjects ranging from environmental law to wage and hour law to civil rights or health care access. And finally, we do litigate. In the most recent years, most of our litigation has been in court. Most of it has been in the very recent time period has been against the Trump administration. I think currently the AG's office overall, I think we have 34 lawsuits pending against the Trump administration. And we have filed in other cases where we're not a party, I think, a total of 68 as of today, friend of the court briefs in different cases, ranging in subjects from transgender rights in the military to the SNAP program to changes in environmental law to the intrusions in personal privacy that DOJ, remember DOJ, that they were trying to bring into the federal government. So we can talk about that a little bit later. But we are the second smallest AG's office in the country, but we punch well above our weight. During the first Trump administration, I was also in civil rights at that time. Our office was in 62 separate lawsuits against the Trump administration, and we won 60 of them. We're having a very high rate of success again, because I think they are doing the same old things that they did before, and they're equally unlawful. So I'll stop there and let it go for Q&A.
Hello, everybody. Hi. First of all, I just want to say thank you all for staying during the weather and for inviting me on this panel, all of you. There are a lot of people in our state agency, a lot of people doing the work within our state government and disability and land access and other things. So to be here, part of this conversation is an honor. Thank you. So what next?
Just keep going.
Okay. Okay.
Zip past.
All right. So my name is Mia Schultz. I am a commissioner, one of 3 commissioners for Vermont's Truth and Reconciliation Commission. So before I get into Vermont's version of Truth and Reconciliation, I'd just like to talk broadly about what Truth and Reconciliation is. It's sort of a worldwide discipline. It started in, I want to say Africa, don't get me started, I think Uganda. But anyhow, it is an international process that examines atrocities that have happened to groups of people and finds resolution through telling of the truth and finding a way through it so that those atrocities don't happen anymore. So Vermont decided that it was important to start its own commission and look at the impact of discrimination and looking at those as discriminatory and as atrocities. So that was through legislation, like like the ORE and like the HRC. We all are also guided by a mandate, by a legislative act. And it was really started out of a formal apology that was made for the Vermont state's role in eugenics, which is the forced sterilization of people. And so its purpose was to uncover and document the laws and policies that enable discrimination, so that we can, again, reckon with that and get to a place where we don't perpetuate those same things. And if we look at how everything's connected in state systems, we know that, eugenics and the idea of eugenics wasn't like the where it started, and it hasn't quite ended. And so we want to really get to the root of these problems and hear from the people who have been directly impacted by the discrimination. And so we have been tasked to look at specific communities who have been impacted. And that means individuals who are Indigenous or Native American, people with physical, psychiatric, and mental conditions, and their families, Black individuals and other people of color, French Canadian, French Indian, mixed ethnic racial heritage, and we added children. So you can imagine this is a big scope of work, and when we look at Truth and Reconciliation in general, usually it's like one atrocity and one group of people. But we have this scope of work that kind of encompasses like looking at it all. So before I tell you about what the commission does, I want to talk about who we are. We have 3 appointed commissioners, Amanda Garces being one. She's here in the room. Shout out to her. Thank you. She's one of our newest commissioners. So glad to be on. There's 3 of us, Melody Mackin, myself, Mia Schultz, and Amanda Garces. We were appointed by a separate process. The governor had nothing to do with my hiring. So there was a separate process of community organizations and state agencies who made the decision to appoint us. So they wanted to keep it, really, this process very separate, the people in charge separate from the state, so that people, well, first of all, they understand that I'm working from that point of view, from the community point of view, not the protection of the state. When you're evaluating the state, when you're criticizing the state, you can't come with that sort of foundation that I'm here to protect, because that's not necessarily what our role is. Our role is not to protect the state in this case. And that makes people scared a little bit, because we've gone through it. Let me tell you, we've had some pushback to that. We also have a team, general legal counsel, who kind of keeps us in check, make sure that we're not doing anything illegal, but also to evaluate the laws and policies that our truth tellers are talking about. Like, what are the implications, to analyze the laws that are implicated in the stories that we hear. We have a lead researcher as well. So what makes us unique about that is that our lead researcher we are not just focusing on what is happening today. We're making connections from yesterday. So our lead researcher is deep into the archives, getting access to those eugenics surveys, and to those into the institutions that were creating violence and harm against our children, and really digging deep so that we can put all these stories in a historical context as well as a legal context. So. And then we have an executive director and a executive assistant. And I just make note, we're all women. So we are a total group of women. And so you can take that however, no commentary needed after that. So what we do is we are currently and actively taking written testimony and verbal testimony. That's both public and private. We just had our last public testimony yesterday, so if I'm a little bit off, those testimonies, if you have an opportunity, go to our website. We have had 5 across the state that are public. They are intense. They are meant to be uplifting the voices of the people. We are mission driven too, and that mission is to uplift and center the folks who have been impacted by discrimination. And that is hard to hear sometimes. And there are a lot of really difficult things, including loss of life, loss of freedom, loss of liberty, and any of the things that our democracy stands for. These folks are really telling and bearing witness to all of it. It's coming like from their gut. And I really, really encourage you to sit in those stories and rewatch those stories. And as I said, we are also have this mandate to research and document and analyze that harm. We also provide community healing and support as we do this. We have been taught by some of the experts all across the globe, including the Canadian TRC, who center care at the heart of this. And so we can't have reconciliation. We're not just going to extract the stories and then just let people deal with them. These are, in most cases, the worst experiences of their lives, and they are telling them to us, and they're giving them to us as a gift. And so healing and support along the way, we not just before they tell their stories, during and after. So it's a really central part of our work, is ensuring that people have a release. They have a release for these, and they felt heard, and they feel seen. And that's not something that government has been really focused on in the past. So I feel really, again, honored to be part of something that centers that for people. And then at the end of this, I should have mentioned, we are a temporary commission. So I became commissioner 2 years ago. I'm working on, I'm gonna say 2 3/4. I'm counting the days. And we're done in 2 more years. So in 2 years, we will have a report with policy recommendations. And then it will be incumbent upon our communities, who we have been asking all along the way, there's community input, all along the way, to help us create and form the recommendations, because at the heart of uplifting the voices of people is recognizing that they have the solutions to the problem. And so we will be ushering in a report at the end of this that will be centering those recommendations of the people who have directly told us how we need to solve these problems. We do not pretend to be the experts of all of the problems. The people closest to the pain get to tell us how to do that. And so we will have a draft report in October 2026 in which the public can give us input, and our final report will be submitted in April 27. But we've taken on, because yeah, why not? We're adding some other things to it, because why not? We're also trying to honor the testimonies that we received. They will not only be housed in Visara, which is the Archives and Records Department, forever here on out. So researchers and other folks, people who are looking up records, will always be able to have access to these stories. We also will be creating an anthology that we hope to give to our libraries across the state, and will feature the testimonies along with the legal and historical analysis. So that's one of the big ambitions we have at the end. And then finally, just sort of a plain language call to action, so that the folks like you here in the room and watching have something to take away from this process, so that we're not doing this for naught, so that we continue to make the work go forward, since it's a very temporary commission. So we're looking forward to that. Should I just close the computer?
Thank you all.
Oh, I just had one more, but I'm good.
Thank you. So one of the things that struck me hearing all of you give your introductions is the overlap and the interconnectedness between all of your work. At the Attorney General's office, it sounds like there's a lot of protective work and prevention work and enforcement work, when those first 2 things didn't work. The HRC, certainly doing enforcement of the state's laws and federal laws. And then on top of that, with training and other opportunities, also that prevention work. The TRC exists to bring us daylight into the situations that occur when there was no protection or prevention or enforcement in the historical context. The Office of Racial Equity largely existing in a sort of prevention way to see how we can get state government's house in order so that the HRC doesn't have to sue us. So thinking about the ways in which we're each operating in those different parts of the cycle, I'm curious to know the thoughts of our panelists about how do you see it being important to be able to pivot and use those different strategies at different times? We've heard things like mediation. We have things like archivists and record keeping, right? We've got work in the courts, work outside of the courts. How do we make best use of all of those different strategies? How do you all decide which tools to use in your toolboxes? And I think perhaps I'll start with Julio.
Sure. For our office, and in the Civil Rights Unit, I'll talk about that because that's where I have the most experience. We really start with kind of the individual or the community first. What is the problem individuals or communities are facing? And then to communicate with them either through organized events or one-on-one, or through their advocates, what they want, what they need. I think the legal profession, as long has acquired a bad habit of this thinking it knows what's best for people. And so we try very hard to figure out what people want, and then we brainstorm and figure out what our options are. And sometimes we don't have the luxury of those things because we know what the answer is. So the day after President Trump issued an executive order trying to end birthright citizenship, we were in court because the prior year we'd been having a national conversation about what we thought was going to happen. But I think that our orientation is to figure out what people want first. Lawyers like to go to court because they've been trained their whole professional life about the successes and failures in court. But for a lot of people, court is absolutely the wrong answer, and that's been a slow and sometimes painful for egos a process for our office to learn over the years, which is figure out what folks want and then see where we can point them if we're not the right people. And that's why it's huge to have the relationships like with the HRC or the NAACP, because if we don't enforce the law, maybe it's something the HRC does. They have a great mediation program, and we work with lots of restorative justice centers where even the legal system itself, it doesn't matter what courthouse, the answer is no courthouse. We try to get the right folks in the right hands to work together. And the last thing I think I would say about our approach is that we're trying very hard to get all professions in the state and local government to drop the sentence in their vernacular of there's nothing we can do. Sometimes what we're saying is we can't go to court, but that doesn't mean there's nothing we can do. We've learned that lesson, are still learning that lesson, and when we deal with other parts of state and local government, we're trying to get them to think that way as well. Just because you can't take someone to court or take some narrow administrative action doesn't mean there's not anything you can do, and to be a bigger and more creative thinker.
I think the way that both of our offices are set up is to address the reality that if we just had these anti-discrimination protections on the books, they would never get enforced by most people who experience discrimination on their own. They're not going to have the resources to go to court, get a lawyer, convince them to take their case and file in court. And that there is a need for the state, capital S, to try to address discrimination and hopefully prevent those cases from needing to ever go to court. And so both of our offices serve this function of also trying to help mediation, or what our statute calls conciliation, that I think is really valuable. And the statutes that prohibit discrimination really wouldn't have any teeth unless there were agencies and full-time people working to detect that discrimination and put a stop to it. And then I think that the prevention piece is twofold. It's letting folks know what their rights are, so that they can file complaints with us if they need to and advocate for themselves. It's letting people know what their obligations are and how they can violate the law. And then also the other piece aside from education is policy work and advising legislators and other entities in our community that are carrying out policies and want to do it equitably and with the considerations of our most marginalized community members in mind.
Actually, for you, Mia, I wanted to touch on something that we just heard, which is we've got a bunch of legal actions being taken on the state's behalf at the national level. We have work that's happening at the local level and at the state level, and things like mediation or litigation or other ways of enforcing the state's human rights laws. But thinking about your role in both of the hats that you wear, I know you're here as a Truth and Reconciliation Commission commissioner, but we also know you as the president of the Rutland Area NAACP. Can you tell us a little bit about how you can advise community members on how they can interact and engage in this moment while the lawyers are doing their thing, while the state bureaucrats are doing their thing? What can actual real human people be doing in the meantime?
So it sort of depends on the people. Are you an impacted person? Are you a person who is directly impacted in this moment or has been over generations been impacted by state and national discrimination? Or are you, sort of not in that category? You haven't really had that sort of experience, but you still want to be able to be engaged in the work. So in the particular case of the commission and Truth and Reconciliation, we've made painstakingly accommodations for people to be able to come to us to talk through the harm that they've experienced, confidential spaces, just, lots of one-on-one relationship building, and yet still, there's still an overlying hesitancy to talk, especially now, because all of the messages say, if I speak, I will be retaliated against, it will make it worse. And what good does it do? Because we still have to do the lawsuits, we still have to go through and maneuver through these processes that take years, sometimes, like years of emotional battering. And so, the road to justice is long, the road is hard. And so for those people, I just say, continue to have the private conversations, and we can talk about where the gaps in the laws are falling through. And if we don't have that input, we can't make it better. So I hope that you feel safe enough to come to us. But those who don't have those experiences but care, like, create that environment for people to feel safe to tell their truths and not exploit them, but to help them through the process, support them. We've seen a lot of people across the state who have shown up to our public meetings just to listen and bear witness and feel that pain, and then take the action that comes from that and really push the legislation to be better and to have accountability baked into it. Because there's a lot of times the laws are present, but getting to the place where you're the HRC and you're in the Civil Rights Unit is long, it's arduous, it's painful, and let's identify what those gaps are in accountability that need to happen, and so that, quite frankly, you don't have as many cases that you have to deal with. That's really what we're trying to get to. I don't know if that
Yes,
answers.
let's get me out of a job.
Yeah.
That would be okay, right? Because then we wouldn't need to be doing all this work of preventing and responding to discrimination.
Absolutely.
Mia, one of the things that you just talked about was the real risk that people face when they do get active and when they do speak up, the risk of being retaliated against or being doxxed or otherwise harmed just for being present in a space. And I know that the state does have some people who are intending to have our backs on that point, and I'd love to take it to Julio and ask, what does the AGO do, or what can the AGO do to help protect our private information from the DOJ-like databases or entities?
Sure, I think that's, it falls into two of the tasks that we carry out. One is the education task, and the other is litigate, the litigation work that we do. Right now, we have a federal counterpart for enforcing the employment discrimination laws called the Equal Employment Opportunity Commission. That's really been a fully functioning office since the mid-'70s, and this is the first time in its history that it has really retreated from protecting folks in this country from workplace discrimination. So it currently will not enforce discrimination allegations involving gender identity or cases involving so-called disparate impact, where you might have a neutral rule such as a height requirement, but it falls disproportionately upon one class or another, like women that say are people from particular national origin, or standardized tests that have no bearing on the job but tend to screen out people in a racially discriminatory manner. They're just backing away from that work. And there's a lot of concern that people have when we read in the newspaper that the administration tried to get the Social Security Administration or Medicare, Medicaid to provide patient or receiver, people who receive those funds to share that with ICE and Homeland Security. So we did two things. One, we educated people about the risks that are involved, and then we also litigated. We took the Trump administration to court, and we blocked their sharing information from Medicare and Medicaid with Homeland Security, and that injunction remains in place today. So, we can't predict always what the administration is going to try to do, but I think what we can do is anticipate the worst and to try to prepare people, so if they are sharing information with the federal authorities, that they're doing so in a way that's limited and they're doing it with their eyes wide open, and then also to be active in protecting Vermonters' rights of privacy from misuse or abuse by the federal government.
Thank you. Now, a lot of that tends to be in response to the often erratic things that are coming out of the White House. So it seems like you're responding to rapidly changing and really emergent issues. And I'm wondering, Big, could you tell us a little bit about whether your agency is also having to do a lot of in-the-moment pivoting and adaptation, or have you, how has your work changed in recent years, if at all?
Okay, that's a really great question.
All my questions are great questions.
And I wonder where you got it from. Okay, so with the federal dynamic, we have often been able to rely on guidance from especially HUD, the Department of Housing and Urban Development, for a lot of our fair housing enforcement work, because we dual file cases that fall under both state and federal law, and we have an agreement with them that they're going to pay us for our fair housing cases, and we do not see that is going to continue much longer, based on how that program has been fairly annihilated and is being dismembered. They have started to withdraw a lot of their guidance documents, and my response to that is, okay, we'll just make our own, fine. I don't need you, federal government, to tell us how to interpret state law. We will interpret state law as protectively and remedially as we possibly can, because that's our mandate under our enabling statute. In many ways, it is spurring us to kind of double down on our work as much as we possibly can, because these agencies that we have often felt like in partnership with from the federal government are really deprioritizing the work and changing, kind of what would be the historical reasons that we would do enforcement now. So It's happening though at a somewhat fortunate time that we have managed to eke out of the budget process in the state legislature more positions that will enable us to fill some of the gaps that is happening with federal inaction. And you know, the broader question of how we've changed, you know, like I said, we have expanded our staff from 6 to 9. Our caseload has doubled and almost tripled in some areas. And we do feel that there are more and more individuals contacting our office in recent years than we have ever had before. And as a lot of the advocacy and support organizations lose funding, they're calling us more because they looking up their rights on Google and there's a Human Rights Commission. So we feel an increase in urgency and importance of our work, and we feel an increase in need. So while we have continued to expand our reach as much as we can and our impact, we also anticipate that we need to continue that expansion, and that where we're at now with 9 employees is only barely allowing us to maintain a status quo of a few years ago. And so if we want to meet the needs of what's about to unfold and what is unfolding, we still need to continue to push for increased funding and resources to enable events like this, as well as amping up our enforcement.
That's a really important point, because I think a lot of people who are doing work in these areas are noticing that we're fighting very hard to maintain just where we are, and where we are has never been good enough. Speaking of where we are, Julio, how many lawsuits are we up to right now?
As of this Sunday, 34, but
34.
more to come.
And yet there's always more to do. One thing that I heard from each of you 3 is the importance of centering the needs of the people we're representing and the people from whom we're hearing. And I want to ask this particularly for Mia and for Big, what can you help us understand about internalizing and about vicarious trauma?
You want to go first? You go ahead.
Yours is probably worse. So I'll go first.
You go.
It's really hard. It's a constant, you know, and we are trying to provide a lot of like customer service. So when people contact our office, they talk to a human being. We have more capacity to have a human being actually answer the phone. People are often calling us in crisis and great distress. You might say, hello, this is the Human Rights Commission, and then someone is talking for the next 5 to 10 minutes, just unloading a story on you that is probably not something in our jurisdiction, but we recognize that they've probably called 5 other people and been referred, or kind of this is their last resort. So we are really trying to be caring and compassionate in holding space for what they're reporting to us, and trying to see, can we take this story that you're telling us and see where there might be something that falls in our jurisdiction? And when we aren't able to do that, can we give you a meaningful referral? Can we actually hand you off to another person that could talk to you? Which is something we're trying to have more and more capacity to do, rather than just give you the phone number for legal aid that will be a voicemail and hopefully they'll get back to you in a couple weeks, you know, because of the demand there. And I think we feel a lot of personal grief when we aren't able to be of service to folks that we know are suffering and are not finding a system that is responsive. So we have been trying to do build in support mechanisms for our team so that we can sustain. There has been a tremendous amount of turnover in our office just since I got there, because of how draining and exhausting and painful it can be to work within this legal system that is ferociously disappointing for everyone involved, including our staff, especially lawyers who are, we are trained to advocate for people, but we are forced to play a neutral role in most of our work at the HRC, and that can be really gut-wrenching, and it can, and we see people are not satisfied with, like, you're the Human Rights Commission, why aren't you helping me? It is a very difficult road to walk, and not nearly as hard as the people who are being discriminated against, and we struggle with that, and try to, take care of ourselves through that process. And I'm a big advocate for boundaries and time off and, self-care and mutual support.
And yes, you're asking this question, like, I think 24 hours ago, we were bearing witness to some truths that were really hard to witness, and actually still are housed in my body and my fellow commissioner here. We still reeling in the intensity of hearing the truths and the raw truths of people. And so what we have the advantage of it actually, that y'all don't necessarily, is that we can infuse love, compassion, not that you don't, but we can, like, legally, just like, we love you. We can surround our work in love. Like, your government can love you. We are government people who are surrounding our work in love, centering love and compassion. And that is what keeps me going, is that I can now use that love to see a new future in government. And it's hard still, like I'm not saying that's that's okay, that I can take it, give me more. I'm just saying that it gives me solace, that I can wake up and say that my work is rooted in love and compassion for other people. We also listen to people without judgment, without interrogating their story and truth. But wait, like, give me the details. Like, we're not doing that. We are inherently believing them. And I think that is something that is in alignment with who I am, and that is how I am able to do the work and go forward. Because otherwise it's just too restricting for me, and I probably would have burnt out a long time ago.
I am tempted to keep going, but I want to make sure that we are able to address audience questions. We received 2 through the Whova app, one prior to today and another one that came in a little while ago. I want to address the one that we got for this panel. I don't know when it came in. I saw it yesterday.
Look at you, you're so good checking the Whova app for us.
She's the best facilitator. Telling you.
The asker asks, long COVID disproportionately affects disabled, LGBTQ, low-income, and new American Vermonters, including children, and many struggle to enforce their rights because investigations take a long time and most people can't get legal help. How are your agencies strengthening timely enforcement so that Vermonters actually receive the protections our laws promise?
Oh, I hate the delay in our investigations, and we have definitely speeded them up in the last couple of years, and we're really proud of that. But part of doing a really comprehensive investigation means that it takes time, and we write long reports detailing all the facts and doing a legal analysis, and that takes time, and it takes time when new cases are coming in every week that are now on your caseload. So we really feel that struggle, and we feel the urgency, and it's really hard that we often have to tell people, like, I hear that we could probably accept this for investigation, but you're not going to get an outcome in that for a year. And so we try to, like, do some, at least, like, be really transparent about that. Like, I'm not going to promise you that in 30 days we're going to have an answer to this at all. It is one of the great frustrations, I think, that anyone who has had any role in a complaint with us has, and it's a great frustration of our team. Again, just another reason that we need a lot more investigators to be able to have lighter caseloads and move cases much more quickly. How is your office with timing on complaints and
Sure.
the struggle there?
In the Attorney General's office, again, we have more discretion about how we handle cases, so we don't have a statute that requires like a vote by an administrative body to make a finding. The statutes, like the Fair Employment Practices Act, just simply says the Attorney General has the authority to enforce the provisions of the law, so we have a lot more flexibility. Just to step back a little bit and talk about the frustrating legal system. So in Vermont, like in employment discrimination, you don't need, if you do get a lawyer, you can go straight to court. Under federal law, usually you have to file a charge of discrimination with the EEOC or some other federal agency first. If you filed tomorrow a case in Superior Court, and it was a case that was going to go all the way to a jury trial. Most cases don't, but if it did go all the way, you're looking at about 3.5 years. So I think that places the HRC's one-year process in perspective a little bit. Most people that come to us don't or can't get a lawyer, and so we do all that work for free. And sometimes when we do the investigation and we make a finding, then lawyers are suddenly interested because we've done all the work. And they pick up the case with all the recorded interviews, all the documents, and a finding from the AG's office of a violation of law, and then they want to take it to court where they get in line for another 3.5 years if they can't settle the case. So what we try to do is to use our mediation program at the outset. We also do something in cases, far from all cases or even most cases are suitable for it, but we do something that we informally just called phone law. That sometimes we'll find about some situation where it looks like the employer is not following the law, and we'll ask the person who we're working with, who made the complaint, is it okay, before we get into a big filing a charge and starting the subpoenas flying, is it okay if we just write a letter or call the employer on your behalf and say, hi, we're the AG's office, and if what we hear is true, then you guys are not in compliance with the law. Do you have legal counsel that could talk to us? Usually we hear from a lawyer within a couple of days. Those could be cases like we have some cases where someone needs family leave because their kid is undergoing chemo, or they are having major surgery because of, they're expecting a child, the employer's not following the family leave laws. And so we try to take those cases and just do with them really quickly, and try to do it over the phone, do it very quickly, and from any source. Like I remember one we received from Pride Center a few years back where someone was transitioning. They worked at a grocery store that you would recognize the name of. The ownership is not an estate that protects workers on the basis of sexual orientation and gender identity. And we learned that this person was coming back from leave, and we're not going to be able to use the bathroom that was consistent with their identity. So we wrote a letter to the headquarters out of state, and they called me on my cell phone on a Sunday because their general counsel did, and they didn't know what the laws were in Vermont. And we said, well, this is the law, and let us know whether we would serve the complaint on you, or do you have lawyers here in Vermont if you don't remedy this? And they remedied it, so the person showed up on a Monday and was able to use the bathroom and other facilities consistent with their identity. Now that's a great, hopeful story, and they are rare, but we have to think, but we do get those cases, and we ask ourselves and everyone that comes in the door, is this one of those cases that we can resolve quickly? Because a lot of our cases will involve, and just for employment cases, we do all private sector cases in Vermont. The Vermont laws cover employers with one or more employees, so every employer, except for the state of Vermont, is subject to those laws that we enforce. So we deal with a lot of different workplaces, and a lot of people have needs where they're still working, and so there's a relationship that is still working at some level, and we try to see if we can intervene. But it is very hard. You know, we have currently 250 open investigation files. About 120 of those are really an active investigation. And so there's a line, and the line's getting longer every year. 2023 was a record year for us until 2024 broke it. And we're in the third quarter of 2025, and we've already broken last year's record. Because as the federal government retreats from civil rights enforcement, people are coming to Vermont, and we're happy to help everybody that we can, but we always can't do it as quickly as we'd like. And that's just, that is a resource issue, and we're trying to be as creative as possible. So those are the different ways that we're doing it.
Yeah, I want to just piggyback on that, that our office does also have an informal complaint process that is like the letter, the sternly written letter with the letterhead. And it is a tool that I'm starting to be more and more willing to use to see if I can solve a problem before we need to undertake an entire investigation.
Thank you.
And Mitch has our Q&A mic.
Yes, we had one more in the app, but I do want to pause and invite people who are in the room. We have time for a couple of questions and some brief responses.
This is a very, very quick question. It is directed towards Julio. When you were talking about the free mediation service that your office provides, you mentioned it in the context of employment law, but does that service apply to all areas of law that are covered by your office?
We have a similar program in our public protection program. So when we're dealing with frauds like scams and things like that, we have a program, the Consumer Assistance Project, that we run out of UVM, where we work with students, and we have a mediation program there. They actually do more cases than we do in employment law. So those are the cases right now where we have them, where we actually use like hired mediators.
Anyone else in the room with a question? Someone will come to you with a microphone in just a moment.
Given all the racial tensions and racial biases within the state and within the state-ran programs, how do you mitigate your own personal racial biases when it comes down to considering which cases you take on?
Is that directed to anybody in particular?
And
Hey.
Julio.
That's a question for me. I hear it. It's a really important part of the work is to always check the privilege and bias that, you know, is inherently part of being a human being. And for me, I have identified enforcement priorities, including racial discrimination, as a priority. Like I said, we can't take every case that that is presented to us, and we do prioritize racial discrimination as a set of cases that we want to take more of if we have a resources decision to make. I think we are always engaged in conversations amongst our team and doing professional development to help us continue to grow our understanding of our own individual bias and how that can impact our work and our personal lives and the world around us.
For our office, we do a few things. First, at the intake stage, I mean, we do a neutral investigation, but at the intake stage, the test that we apply is we assume everything you tell us is true. So we will take, regardless of whatever evidence you have to back it up, whatever comes in writing or it comes from you or people that you bring to us, we'll assume it's true. And then we'll look at the law and we'll see whether it meets the legal standard. And if it meets the legal standard to do an investigation, then we're going to do an investigation if you want. Some people don't want an investigation or they don't want one yet. So again, we go back to centering them. What do they want? If they want an investigation, we're going to do the investigation. And then, you know, we are trained investigators and lawyers. If we're going to vindicate someone's rights in the legal system, we have to collect the evidence, and evidence comes in all sorts of shapes. Most people do not admit to discrimination, so it's hard to build those cases. That's part of why cases take a long time, because you may find, and often we find the missing piece of a puzzle is somebody's text message that they didn't originally produce to us, but maybe the person who was on the text thread did provide a copy of it. So we try to be careful in the evidence we select. And the last thing, we do a lot of training on anti-bias, and not just racial bias, but all sorts of bias, including confirmation bias, which is just a way we tend to highlight evidence that fits our theory of the case and minimize evidence that doesn't fit our theory of the case. And then finally, we have a kind of an internal, informal process where we challenge, almost every decision we make is challenged by another person. So if an investigator says, I think we're going to close an investigation because we don't have enough there, we don't get to that stage until one and usually two lawyers challenge those conclusions and put the investigator through trying to convince us that that case should be closed, or alternatively, if they think there should be a finding of a violation, we challenge them to lay it out. We have a former intern in the room with us today. I won't out them, but we sometimes find with our intern and extern process that they're surprised by how harsh that can get, that challenging, where they thought they had a good analysis, and we're telling them, you know what, go back out and look for some more evidence. There are 2 witnesses who are out of state, go find them, because we don't think you're done yet. And I think that's one way we can try to do it, is to build as complete a record as possible. And I think that, we can do better on all of those things, but I think those are processes that have been helpful, and we found that going back out and hitting the bricks again, we find more cases where we can make out a case of discrimination.
The last question that we received, this one came through by email. Again, I'll ask for brief responses for anyone if they have one. And the question is, how, if at all, are your offices addressing the disparate impact of the governor's return to work order? I'm just going to put a friendly amendment on that. And instead of return to work, I will say return to office space order. We have never stopped working. And I suppose because our office is embedded in the administration, it's appropriate for me to give a brief response here. In the spirit of transparency and respect for everybody who's here today, to speak candidly, the Office of Racial Equity was not consulted before or during the rollout of the order. And 2 of our staff persons do not have designated workstations as of yet that they know they can go to when this rolls out in 2 weeks. So we are doing the same legwork that many of our organizations do, which is navigating how to adapt and how to kind of elbow your way into a place that perhaps you thought you would have been proactively invited to. So we are still very actively looking to embed more equity protections and considerations in the policy as it rolls out. I imagine that you all may be hearing a lot from state employees when this happens. What do you anticipate there?
Yes, we have heard a lot about this, and I have also been involved with the Governor's Workforce Equity Diversity Council, which was also not consulted about this decision. I want to commend the Commission on Women for putting out an outstanding memo outlining, before it was decided, outlining the concerns about the disparate impact and the equity considerations of what some call a return to commute. We definitely are, as they have continued to carve out various exceptions and changes, we're glad to see that, and we are absolutely keeping an eye on how it does actually impact the workforce. And that's all I can say about that.
I find myself these days so often closing remarks with, "That's all I can say about that." And speaking of closing remarks, I want to thank everybody who is here, virtual or in person, with us. We are about to wrap up, but before we do, my brain is swirling with so much of what I've heard today, and I hope you all will indulge me while I track us back through some of what we talked about. We heard from attorneys, non-attorneys, community justice advocates. There are a lot of hats being worn by these panel members, and a lot of strategy about when to wear your hat, when to take it off, and when to hand it off to someone else. We heard from Julio, who said, if having the AG's office show up is adding gas to the fire, we step back and find the right people to step in. And sometimes those people are members of community-based organizations like the ACLU or the NAACP. We heard about what it means to center people and to center stories. Mia, I was so struck by the way that you worded something. You said that in the research the TRC does, you all are evaluating the laws that are implicated by the stories you hear, which I thought was such a great way to put it, because some people, particularly those with legal training, often will center laws as timestamps in history and then figure out what happened to people around them. But what you've said is we're hearing the stories, and whatever laws are implicated through them, we can chase those down. I thought that was really, really key. We also talked about the can-do attitude that we all have to have as people inside and outside. Julio, you talked about trying to get other places in government to drop the vernacular of "there's nothing we can do." Because even if you can't go to court about it, there's still something you can do about it. And I think that, Big, you spoke to that as well when you talked about retreats from federal entities, things like rolling back of guidance documents and even funding, where you said, we don't need you, we'll make our own. And then you went on to talk about the importance of filling the gaps created by federal inaction. And I think that as we're talking about community involvement and what people can do, it's so important to remember that sometimes inaction by your local, state, federal, or other government or pseudo-government entity, yes, it can be a disappointment, but it's also an opportunity to be able to fill that gap. And then finally, Big, you talked about the quandary that sometimes is presented to you in your role, where you said, we're trained to advocate for people, but forced to play a neutral role in cases, and the tension that that creates when you are perhaps purpose-driven, but also process-constrained. So I want to ask all of you to please join me in thanking our panel members for their wisdom today. And I'd like to close with one more quote, not from a panel member. It came in the chat of this session on Whova. While we were speaking, Mia, you had talked about how your government can love you. And one person who's watching online responded by saying, thank you, Mia. I shared my truth a few months ago. It was cathartic. I did feel cared for and heard. Much appreciated. Thank you.
Thanks, everyone. Hi. We love you, Vermont. That one is
Don't
John.
let it stay here.
Thank you.
You know, we're in a hush.
Do your surveys.
Do the surveys.